Well, joined now by Adv.Mthunzi Mhaga, NPA spokesperson. Good to have you, sir, and thank you very much for your time.
Compliments, Thabo, and the viewers at home. Thanks for having us.
No, it'll be a pleasure, and all the best for you as well for 2026. Well, the ConCourt has now remitted the matter to the High Court to determine the remaining grounds of the special plea that Ms. Cholota is going to bring. But I suppose what is key here is the clarity that you sought. The NPA was firstly of the belief that you had authority to initiate an extradition. That matter is now settled, right? And many people are asking, why did you behave in that manner? Were you objective in your approach? Were you fair in your approach?
We took the view, Thabo, that prosecutorial independence would have been compromised in circumstances where we are told we are only going to prepare the paperwork and submit for further transmission. However, the Apex Court has now settled the matter, and is the court of which serves as a final arbiter on these matters, and as such is settled. No, we accept it. We don't go beyond that. That was our interpretation. That was how, in practice, it had been done, and it had never been pronounced on. That's why we sought to get a final pronouncement by the highest court in the land. It is now settled. However, if I can zoom in on the Schutz judgment, where we were only blown on the issue of late filing of the application for leave to appeal when our condemnation was dismissed. However, the court did not deal with the retrospectivity of the Schutz SCA judgment. So in essence, our interpretation and the firm view still stand that the Schutz judgment doesn't have a retrospective effect. In essence, it doesn't have a bearing on all matters that would have been approached the same way that Schutz was approached.
Yeah, so in other words, you are trying to deal with the, lack of a better word, Cholota strategy, that others may want to use that same, and there are other extradition cases that are actually still in the courts, and people might want to revert to this.
No, obviously, that's why we're saying it was a good day in the office for the NPA. And if you listen to the judge, when he dealt with Schutz, he only dealt with the condemnation application only, and there was no pronouncement on retrospectivity. Even the Schutz judgment did not deal with that, and made it clear on paragraph 16 of the judgment that this relates to ongoing matters. That means it would not affect those that would have been submitted before the judgment of Schutz. But if you go to Cholota, it's a great judgment for us. It's legally sound, because it's a vindication of our long-held view that the fact that you are challenging the unlawfulness of the extradition order should not fail to engage the jurisdiction of the court. Right. Now we're given an opportunity, and Mr. Cholota was saying there, that the matter will be remitted, or has been remitted to the High Court for the issue that relates to the special plea that they had raised. That the rest of the grounds should now be determined.
So she's still going to challenge extradition. Then she has now the right to challenge it, because the court has said jurisdiction has been established.
Well, not the issue of extradition, because it's been declared to have been unlawful. But the judge says it does not deprive us as the prosecution an opportunity to engage the jurisdiction of the court so that she can be prosecuted.
Yeah. So, but she's still going to bring, the other matters of a special plea, where she argues that the state misrepresented itself in the U.S. authorities, and therefore there's a challenge to that.
We are ready for that. On Monday, the matter is coming back on the roll. Currently, the legal team, that is our prosecution team, is engaging meaningfully on the matter so that we can find a way of enrolling and having these remaining grounds of the special plea ventilated by the judge. But the issue that relates to other accused persons will be dealt with on Monday. So we will meticulously argue for the special plea to be dismissed, because we believe it lacks merit.
You are still firmly of the view that she is a flight risk, connections to Kenya? These are some of the issues that she's going to challenge.
Let's not get into that, because it has a bearing on the extradition. If you talk about the issue of flight risk, links to Kenya, it would have an effect on bail issues and all of that. Our focus is to say we have a formidable case that she has to answer to. Allegations that are serious, that we plead the court to hear us on them, allow us to present that case. And if she has a valid defense, let that be tested in court. We are saying challenging the unlawfulness of the extradition should not deprive us of an opportunity to have the criminal charges we preferred adjudicated. The ConCourt agrees with us. Yeah. That's why I'm saying...
But what's the net effect of that? I mean, others are saying it's good for you. Yes. The fact that you won't have these things limiting the execution of justice. Yes. But what about people who will be extradited wrongly for all sorts of other nefarious reasons, and to say, well, they've got no grounds now to say, well, this extradition was unlawful?
Look, we will deal with every matter as it comes, deal with it on its own merits moving forward. In relation to other matters, but those that we are seized with, we are obviously going to follow the ConCourt judgment. But I indicated earlier that we interpret the Schutz judgment and the ConCourt's not pronouncing on the retrospectivity of the Schutz judgment as an indication that it was never meant to be.
You don't anticipate now a situation where, again, you'll be taken on legal challenge on the question of retrospectivity?
It's an interpretation that we believe is legally sound. And we are ready and we are armed to meticulously argue that Schutz's SCA judgment was never meant to be retrospective. And we have paragraph 16 of the judgment that makes it clear that it relates to this request and not in any way have a bearing on other extradition requests. That's going to be our argument.
One of the claims that came out of there is that there is this conspiring that is taking place between the police and the prosecutors who arrested her to subject her to cruel treatment and mental torture and threatening her liberty and freedom. What do you say?
But that was an allegation. If when it goes back to the High Court, the matter is raised, we are ready to oppose such. We are ready to argue for that to be dismissed as baseless.
Baseless, I mean, obviously don't want to get into the matter that you're going to be arguing in court, but let me try anyway. On what grounds?
No, there's evidence that has already been led to that effect, where the investigating officers that traveled to the US denied that she was ill-treated. And if that grounds needs to be ventilated again as one of the remaining ones, I am making it clear that we will mount a very strong argument for it to be dismissed and will be countered by arguments that the prosecutors will be presenting.
Advocate, thank you very much for your patience and sitting through the presentation by Julius Malem, but waiting patiently for us to bring this matter.
I'm not part of that. And it's in the Eastern Cape. I'm in Joburg.
We appreciate your time and thank you very much for coming through. That's spokesperson for the NPA, the Adv.Mthunzi Mhaga.